Today we will be conducting training on gender and age discrimination in the workplace. Gender discrimination refers to treating individuals differently in their employment, specifically because they are a woman or a man. Age discrimination refers to treating individuals less favorably because of their age. This can occur in all age groups, from the youthful to the elderly. Why does age discrimination occur in the workplace? Reasons can include the employer wants a younger look for the company, the employer needs new blood in the company, or the employer wants to keep the younger, less experienced personnel, therefore saving money as they are paid less.
Rachel, you're doing great. How about a promotion?
Oh my gosh!
Fantastic speed, Mark. How about a promotion?
Oh, swing.
Hey, Ashley, how about a promotion?
Yes! You look like my grandpa.
Always passing on the older guy.
Why does gender discrimination occur in the workplace? An individual may apply for a job and has the proper experience and qualifications for the position, but may not be hired because some of the longtime clients are more comfortable dealing with one gender over the other. Some professions have traditionally been tailored to one gender over the other. The majority of women work in professional office and administration, support, sales, and service occupations. Men usually work in construction, maintenance and repair, production, and transportation occupations. In 2013, nearly 40% of working women were employed in these occupations, compared to less than 5% of men. And 45% of men worked in these occupations, compared to less than 6% of women. In 2013, median annual earnings in the United States for women working full-time year-round was $39,157 and $50,033 for men. The pay gap between men and women has narrowed since the 1970s due to women's progress in education and workforce participation. But in 2013, women working full-time in the United States were still only paid 78% of what men were paid. In the healthcare organization, the employees work with the public. With any discrimination, the routine, service, and quality of care the public can receive is affected. Medical care is vital, and when an employee is mistreated, they may not work to their potential. There is no room for issues in the healthcare setting. Believing that an employer is fair improves workers' morale, and employees are less likely to be absent, therefore resulting in better care provided to patients. In June of 1941, the first presidential action ever taken against employment discrimination was signed by President Franklin D. Roosevelt. This executive order prohibits private employers that hold government contracts from employment discrimination based on race, color, or national origin. President Roosevelt signed this the day before World War II to ensure there were no strikes or demonstrations disrupting the manufacture of military supplies. Even though this law was passed to prevent disruption of military supplies, it started the beginning of preventing employment discriminations. There is currently legislation regarding discrimination in the workplace, including in 1942, a New York Congresswoman introduced a bill prohibiting discrimination in pay based on gender, but it did not pass. 21 years later, President John F. Kennedy signed the Equal Pay Act, or EPA, of 1963. The bill states, "No employer shall discriminate between employees by paying wages to employees a rate less than the rate at which he pays wages to employees of the opposite sex for equal work, which is performed under similar working conditions." In 1964, President Lyndon B. Johnson signed the Civil Rights Act. It originated from President Kennedy, but was intentionally held in Congress. After his assassination, President Lyndon B. Johnson addressed legislators stating that no memorial could more eloquently honor President Kennedy's memory than the earliest possible passage of the Civil Rights Bill, for which he fought so long. 7 months later, it passed in Congress, and President Johnson signed the bill into law. It contains 11 titles, and Title VII outlaws discrimination by employers based on race, color, religion, sex, or national origin. From Title VII of the Civil Rights Act of 1964 came the Equal Employment Opportunity Commission, or EEOC. Creating this agency gave power to Title VII, even though it was weak at its beginning. With each new executive order or amendment added to the Civil Rights Act, it has grown so that employment discrimination claims would be investigated, expanding and directing the Commission's responsibilities and authority. The various laws that govern EEOC's actions are subject to interpretations by the federal court system, and most importantly, by the Supreme Court. Today, the EEOC has more than 50 field offices and investigates more than 80,000 claims of employment discrimination annually. In July of 2014, the Commission celebrated its 50th anniversary. In 1967, President Lyndon B. Johnson also signed the Age Discrimination in Employment Act, or ADEA. It forbids employment discrimination against anyone at least 40 years of age in the United States, and only stipulated up to 65 years of age. In 1978, President Jimmy Carter amended the law, making several changes, including raising the age of employees to 70. In 1986, President Ronald Reagan amended the ADEA, completely removing the age limit. In 1978, Congress amended Title VII of the Civil Rights Act by passing the Pregnancy Discrimination Act, or PDA, to make clear that discrimination based on pregnancy is unlawful. It also reversed the Supreme Court's Gilbert decision. In the 1976 Supreme Court case, General Electric Company versus Gilbert. The Supreme Court ruled the General Electric Company disability program did not discriminate against women when the program did not pay benefits for disabilities due to pregnancy or childbirth. The PDA extends the prohibition on pregnancy discrimination to include the receipt of benefits under fringe benefit programs as other persons not so affected but similar in their ability or inability to work. In 1990, Congress passed the Older Workers Benefit Protection Act, or OWBPA. It overruled the Supreme Court 1989 decision in the Public Employees Retirement System of Ohio versus Betts. Betts stated the ADEA did not forbid age discrimination in employee benefits. It only did so in rare occasions. The OWBPA amended the ADEA and prohibits age discrimination in employee benefits and establishes minimum standards for an employee's voluntary waiver of an ADEA claim. In 2007, Lily Ledbetter was one of few female supervisors at a Goodyear tire plant in Gadsden, Alabama. Her co-workers had bragged about their pay, and she learned she had been discriminated against after she received a note showing the salaries of 3 male co-workers. She filed a complaint with the EEOC. Her case went to trial, and she was awarded nearly $3.5 million in compensatory and punitive damages. The Court of Appeals for the 11th Circuit reversed the verdict, stating her case was filed too late. They ruled that employees could not challenge pay discrimination if the pay decision occurred more than 180 days earlier.
I went into work, as I always did, an hour to an hour and a half early, and to get my mail, to check my email. I looked at the mail and immediately fell out a rough, torn piece of paper, about a quarter of a sheet of 8.5 by 11 paper, 4 first names, Lily, and 3 men. And when I looked and saw how much those men were making, base pay only, just base pay, I just felt so degraded. I don't think I've ever had a lower point. Immediately, my mind started calculating overtime, because overtime was a big, it was a big motivator. I had children in college. We had a mortgage to pay. We had car payments. We had the usual expense that families have, and it was so hard to make ends meet. But then to stand there and look at those numbers and just think back how hard it'd been on my family when it was totally unnecessary. And I did not see how I could muster up enough of dignity to get through a 12-hour shift. I finally walked around a while and went into the ladies' lounge and tried to talk to myself and get my courage up, knowing I had to get through the shift. I really wanted to take my bag and go home. I really just wanted to run away and hide. But I couldn't do that. I couldn't, and I had to stay and face it. I got home the next morning. I explained to my husband what I had learned, and I said, unless you object, I want to file a charge with the Equal Employment Commission in Birmingham, Alabama. If I started it, I would be in it for the long haul. I wouldn't be a quitter. And he said, what time do you want to leave?
In 2009, President Barack Obama signed the Lilly Ledbetter Fair Pay Act. With this new act, The 180-day limit to file a claim resets with each discriminatory paycheck. To name a few of the trials and settlements regarding discrimination in the workplace include, in 2011, Vasich versus the City of Chicago. They alleged firefighter tests discriminated against women, stating the test was not related to job performance or predictive of who would succeed as a firefighter. The city settled with the class in December after 2 years in court. In the case of Ellis versus Costco Wholesale Corporation, this settlement took over a decade to complete. In 2002, manager selection procedures were questioned. They were accused of discouraging females from applying. The suit was filed in 2004, and the class was certified in September of 2012. In the case of Easterling versus the State of Connecticut Department of Corrections, in 2013, the physical fitness test of 1.5 miles run was not a business need. They stated it discriminated against female candidates. Over 200 women who had applied for the position in 2004 or 2006 were certified for the class. In order to combat discrimination in the workplace, one must establish policies on such behavior. In regards to gender discrimination, with hiring, firing, and promotions, only in very limited situations should gender be a qualification for a job. It shall be prohibited for employers to treat one employee or job applicant differently than another based solely on gender, rather than job requirements or work performance. In regards to pay, employers shall be prohibited from paying unequal wages to men and women who perform jobs that require substantially equal skill, effort, and responsibility, and that are performed under similar working conditions within the same establishment. In regards to benefits, even though differences between the sexes may result in different benefit costs to an employer, the employer shall be prohibited to discriminate between men and women with regard to benefits. Employers shall not be allowed to condition benefits available to employees, their spouses, and families on whether the employee is the head of the household or principal wage earner in the family unit. That status bears no relationship to job performance and discriminatorily affects the rights of employees. In regards to age discrimination, statements or specifications in job notices or advertisements of age preference and limitations. An age limit may only be specified in the rare circumstance where age has been proven to be an occupational qualification. In regards to benefits, the employer shall only be able to reduce benefits based on age if the cost of providing the reduced benefits to older workers is the same as the cost of providing benefits to younger workers. In regards to apprenticeship programs, it should be unlawful for apprenticeship programs, including joint labor management apprenticeship programs, to discriminate on the basis of an individual's age. Age limitations in apprenticeship programs shall not be allowed. If you are the victim of discrimination, document. Have everything in writing and have a timeline. Know your rights. Contact the Equal Employment Opportunity Commission, or EEOC, at 800-669-4000. Seek help. Speak with your supervisor or a human resources representative to learn about the proper grievance procedure. Avoid comments. There is a threat of a countersuit for defamation. Seek legal advice. Speak with a lawyer with experience in your type of discrimination. Do not procrastinate. There is a statute of limitations on filing a complaint with the EEOC. Manage your money. Speak with an accountant or a lawyer about the costs of a lawsuit. Prepare for the process to take time. Filing a discrimination lawsuit can be time-consuming, but people have succeeded, and you can too.
Knowing the types and impact of discrimination is important, but awareness should not stop there. Managers, supervisors, and coworkers must keep a close eye out for incidents of discrimination within the workplace. Nothing can be changed, prevented, or improved if people do not take the time to get involved. Remember that discrimination is not always obvious. Threats or harassment may take the form of side comments, teasing, jokes, or even gestures. If you observe any incidents of discrimination, keep a detailed account of the incident, including the date, time, location, and names of witnesses. Refer to your company's policy to know what actions will have to be taken. And notify your supervisor or the Human Resources Department.
Thank you for your time. Training brought to you today by April Coggins, Diane Shemek, Danisha Mosley, and Sylvia Shelton.